Tanjanco v. Court of Appeals, GR number L18630, December 17, 1966. Opponent D. Justice Reyes, JBL. Facts. Defendant Apollonio Tanjanco courted the plaintiff Aracely Santos, both being of adult age. Since he promised her marriage, she consented to his pleas for carnal knowledge. They did so frequently in a span of a year. As a result, she conceived a child, and due to her condition, she had to resign from her work. Apollonio refused to marry Aracely as promised and refrained from seeing the plaintiff, which led to her suffering from mental anguish, besmirched reputation, wounded feeling, moral shock and social humiliation. The plaintiff asked that the defendant to recognize the child she was bearing, to pay her not less than 430 pesos a month for her support plus 100,000 pesos in moral and exemplary damages plus 10,000 pesos attorney's fees, basis Article 21 of the Civil Code of the Philippines. Upon defendant's motion to dismiss, the CFI dismissed the complaint for failure to state a cause of action. Santos appealed to the CA. CIA set aside the dismissal and directed the CFI to proceed with the case. CIA agreed with the CFI that no cause of action was shown to compel recognition of the child as yet unborn, nor for its support, but decreed that the complaint did state a cause of action for damages, premised on Article 21 of the Civil Code of the Philippines. Hence, this appeal by defendant Tanjanco to the Supreme Court. Issue: whether or not a breach of promise to marry can bring any action for damages in court. Whether or not seduction has been an element in the relationship between Apollonio and Aracely. Held: no case can be made since the plaintiff Aracely was a woman of adult age, maintained intimate sexual relations with appellant with repeated acts of intercourse. Such is not compatible to the idea of seduction. Seduction is more than mere sexual intercourse or a breach of promise to marry. It connotes essentially the idea of deceit, enticement, superior power or abuse of confidence on the part of the seducer to which the woman has yielded. The facts stand out that for one whole year, from 1958 to 1959, the plaintiff appellee, a woman of adult age, maintained intimate sexual relations with appellant, with repeated acts of intercourse. Such conduct is incompatible with the idea of seduction. Plainly, there is voluntariness and mutual passion, for had the appellant been deceived she would not have again yielded to his embraces, much less for 1 year without exacting fulfillment of the alleged promises of marriage, and she would have cut all relationship upon finding that defendant did not intend to fulfill his promises. One cannot be held liable for a breach of promise to marry. Decision: the decision of the Court of Appeals is reversed, and that of the Court of First Instance is affirmed. No costs.